Our first showcase is our run showcase presented by Brian Rogers, entitled How to Read a Contract. Brian Rogers is a business lawyer who helps business owners buy and sell small businesses. In the course of his legal career, Brian has reviewed 283,496 contracts, give or take a few. This morning, Brian will take us through a typical contract and show us what should be there, as well as what to avoid. Please welcome Brian Rogers.
All right, it works. Okay. Well, good morning, everybody. Welcome to How to Read a Contract. Talking about one of my favorite subjects. As a business lawyer, I come into contact with contracts every day. I help people, who are buying stuff, who are selling stuff. My life really pretty much revolves around contracts, and so I thought I would share with you some of the things that go through my mind when I read a contract for a client, things to look for, things to avoid. And over the years, somehow I've been become known as a great illustrator, we'll say. But with we're going to be dealing with a lot of contract language and things, and so my creative well was pretty dry when it came to illustrating this. So, but I didn't want to disappoint everyone, so I did make a portrait of myself. This is me preparing, the slides, and so anyway, there you go. I also prepared on your tables are 4 different documents. There's 2 contracts. And there are 2 checklists. So, and each of them has a little QR code on it if you want to pull it down from the internet. Also, this is a QR code for the buyer-friendly contract. Here's one for the seller-friendly. So what I did is I prepared, a form contract for you all that we can go over together. It's a contract to produce a logo for a company. And so there are 2 versions of it. One is the customer's version that they would be happier with, and then the other is the artist's version. So to begin with, let's take a quick cruise through the contract. Contracts tend to be structured fairly similarly. And so, let's just go through the different sort of parts of the contract. So first, there's the introductory paragraph. So if you look at, pull out maybe the buyer friendly logo creating contract. So the first paragraph is going to identify the parties. Often it'll date the contract, which is often important. And then after that, there are often a few statements about, why are we entering into this contract? Some, statements about the background. In the old school, they were all whereas statements, whereas this, whereas that. This is why we're entering into this contract. And then after that, usually are the business provisions. And this is the reason that the buyer and seller are actually entering into their contract. It's the business deal. And from my perspective, this is what my clients are usually the most concerned about. And so if you look, my notes aren't coming up on the screen here, but so I don't have it, but the first few numbered sections, the services, the fees, those sorts of things. Those are the business deal, the business provisions themselves. And then after that, there's also often some risk allocation provisions. And these will be the warranties. In the seller side document, there's limitations of liability. And so the provisions where the buyer and seller kind of allocate the risk of the relationship, whether it be the business risk or the risk from other people, suing because of what's going on in the business relationship. And then at the end are what are commonly known as boilerplate provisions. And in the form contracts here, I just put them all It's a simple short contract. I put them all in one miscellaneous section. But these are things that deal with, like the choice of law, notice provisions, those sorts of things. So that's the structure of the contract. So now let's get into what you're looking for when you review a contract. So when you're reading a contract, you want to make sure that the things that you need are actually in there, but you also want to make sure that what's in there isn't just horrible for you. So you're making sure that some things are there and others are not. So here's a QR code for the seller's checklist, or is that the buyer's? I need to update my contacts. So, anyway, and then here's the checklist for the other side. So we're not going to go into as much detail as the checklist here, but I wanted to give you something that you could take away and use in the future for your own business when you are either reviewing a contract that somebody's presented to you, or maybe coming up with your own. So from the buyer's perspective, you want to make sure that you're getting what you're paying for, and particularly when you've got someone building something for you or making something for you, deadlines are super important. And so you want to make sure that you're going to not only get what you pay for, but you're going to get it when you need it. So first off, what are you buying? So if you look at the buy side form contract there, section 1 deals with that along with exhibit A. So the creator shall perform the services as described below and further defined in appendix A. And then in appendix A, you've got a detail of what the logo maker is going to do for you. And from the buyer's point of view, it's important to make sure that you're clear on what your expectations are. Because if you're disappointed in what is actually given to you, you're going to need in your contract something specific to point to that says you didn't do this. If it needs to be full color and it comes black and white, your logo, then if the contract says produce a logo, well, they've done what you've said and what you've required them to do. One of the biggest challenges for me in this kind of contract is to help my clients think through what exactly is it that you need from them to do specifically, so that if they didn't do that, you would be able to point to that and say, you didn't do that. Because if you need to enforce the contract, you really need to have specific requirements. And so appendix A is pretty important. And you'll notice if you compare appendix A from the buyer's contract with appendix A on the seller's contract, the buyer's one is much more detailed, and the seller's basically just will give you a logo, which is what the seller would probably prefer. So next, when will you receive it? So if you look at section 4 of the buyer's contract, you can see that the delivery of the work product is important, and I put it in red here. Time is of the essence. I mean, for the buyer, you want to make sure that if your timing expectations are not met, that it's going to be a material breach of the contract, which will trigger your remedies. If you look at the seller's version of it, it's going to be the opposite. Timelines are, we'll use reasonable efforts to meet the timeline, but if we can't do that, it's not going to be a breach of the agreement. So, and then of course in exhibit A on the buyer side contract, there are more detailed milestones and deadlines and those sorts of things than you would see in a seller-oriented contract. So the next thing are assurances as to quality. On the theme of making sure that you're getting what you're paying for, you need some warranty coverage. And if you look in section 5 of the buyer's contract, there are fairly extensive warranties as to quality, as to non-infringement. You don't want the creator to provide a logo that's going to get you sued by somebody because it infringes somebody else's trademark or something. And then in clause 3, the services and the work product will conform in all respects with the requirements of this agreement to the customer's satisfaction. A seller really wouldn't want those last few words. Do you really want your work to be judged legally on the buyer's satisfaction. I mean, who knows what that is? It's very subjective. A seller would want any kind of warranty to be very objective and clear. And then next, the buyer wants to make sure that they have warranty, or excuse me, remedies in the case of disappointment. And so here in section 8 of the buyer's contract, one of the remedies is to basically pull the plug and terminate the agreement. So if the logo provider, for instance, is really dragging their feet, they're not meeting the deadlines, then at some point the buyer can say, we're just going to terminate the agreement. And of course they can still, sue for breach of contract or whatever. So it's important to make sure that you have some remedies. And some, some contracts, the one that I put together for you all is pretty simple and straightforward. In a lot of contracts, the buyer's remedies are pretty detailed. For instance, for late delivery, you could have a liquidated damage clause, and you see that a lot in construction contracts, where if you're late, then you're gonna have to pay so much a day for every day that you're late. But these remedies can be pretty extensive. And then also the ability to enforce the contract is important for buyers. One remedy, I didn't put it in here, but on the slides. But if you look at the fees provision, sorry, that's on the seller's part. But at any rate, in order to make sure that you can enforce your agreement, it's important to make sure that the other side, if they breach the agreement, is going to have to pay your attorney fees. Missouri, like probably most states, follows what's called the American rule. And as far as attorney fees, which basically says win or lose, you pay your own attorney fees. And so if the seller breached the contract and say you had a claim for $10,000, you consult with an attorney, they say it'll cost $5,000 to bring the claim. You've got a difficult choice to make. You might get 10, you're going to pay 5. If you've got an attorney fee provision like this, then the seller would have to pay your attorney fees too. So that's a really valuable provision for both sides to have in their contracts. So let's flip it here and talk from the seller's point of view for a moment. So when I'm representing sellers, I want to make sure that they get paid. That's one of the most important things. And then also that they're not taking on undue risk. So first of all, we'll look at the payment terms, and you'll see some things in the payment provision of the seller's form that you don't see in the buyer's form. One of them is interest. If the buyer pays late, then interest is going to accrue. Now, in my experience, most people don't enforce that against their customers on a daily basis. Just because someone's late, you don't hit them with interest. But it can be really important if you need to enforce the contracts in litigation, because the whole time that they're delinquent, it could take 2 years or more to go through the courts and get a final judgment and get them to actually pay. And the whole time interest will be accruing if you provide for it in your contract. So that can be a really powerful negotiating tool when you're trying to work things out when things go bad. And then tools for enforcing payment. Interest, of course, is one. Termination, we also talked about. Another one is actually found in the buyer's agreement. In the buyer's agreement, there is a provision that expressly states that the work product is going to be owned by the buyer. Even though it's a seller-friendly provision, for purpose of illustration, I put in there, if you look at the second sentence at the beginning of I believe it's section 3, the work product clause, it says subject to the buyer's payment of the fees under the agreement, then the work product ownership will transfer. So that's a really valuable tool for the seller, is to condition transfer of the ownership of the work product on payment. And of course, termination is another possible remedy. So another thing that buyers want is generally to limit their responsibility and their potential liability under the agreement. And so in section 4, there are several things that ways that the seller does this. One is to have a limited warranty. One is to have a limited amount of time to bring the warranty. And then and to have exclusive remedies that are pretty modest, basically just reperforming the services or giving their money back. But there's also a limitation in section 4C. There's two parts of that. One is the disclaimer of consequential damages, and the other is a cap on liability. And to illustrate consequential damages, if for instance, the seller delivered a logo and the buyer used that logo for, they spent $30,000 on a sign, they put the logo on all their products, and then they get sued for excuse me, for infringement, and then they can no longer use the logo, and they spent all this money. I mean, those are consequential damages, and so the disclaimer of consequential damages clause would protect the seller in those kind of instances. And then the cap will limit the buyer's or the seller's liability under the contract to the fees that are paid, which are going to be fairly modest. So in these ways, the seller can really protect themselves as far as the downside, so that the contract doesn't become an albatross around the business's neck. And then ability to enforce the contract. I'm getting low on time, so we've already talked about some of these. Interest accruing helps. Conditioning transfer of ownership of the work product can help. And then, of course, attorney fees provisions can help. And and termination provisions. In the seller form, the attorney fee provision is a little bit different than the buyer form. There's nothing special about the seller versus the buyer, except that I just wanted to illustrate the difference. In the buyer's form, it's a two-way prevailing party attorney fee. So if somebody gets sued, whoever wins that lawsuit is going to have their attorney fees paid by the other party. This is a one-way provision that only favors the seller. And my time is very up, and so I'll entertain questions. Before I do that, though, I wanted to send you, if you're interested, to an e4e presentation I did years ago, getting paid. And if you want to know why I'm blue while I'm giving blood, there's a QR code to the YouTube video on e4e's website. So we probably have about 30 seconds if anyone has any questions. Yeah.
Yeah, Brian. One of the things I found that even as a seller, when I'm creating a contract, because it's customized consulting service, that in the contract, I also indicated what they were responsible for doing. And I found that it was really helpful on the few instances where they'd come back and say, Dale, I don't think we're getting the value that we're paying for. I'd say, okay, well, let's go back and look at the contract. And I'd say, well, I was supposed to do this, and yeah, you did that, and you're going to do that. Oh, okay. So when are you going to do that? It saved me from a big to-do because I was able to demonstrate in writing that they agreed that they were going to do this, and they weren't. So even as a seller, being specific about those responsibilities, I found to be very helpful.
Yeah, that's a good point. It also illustrates another point, is that one of the purposes of a contract is to help the parties think through what they're really agreeing to. And what I found is that the whole contracting process can really help people to stop, slow down, think about what exactly are we doing? What do we need in this contract? And that's a good illustration of, what you would want to think through. Whose responsibility is it to do this or to do that? Mr.
Just pros and cons to arbitration.
Pros and cons to arbitration. That is a really good question.
whole other presentation.
Yeah. And you could ask 5 lawyers and you'll get 7 answers to that probably. But one of the benefits, the purported principal benefit of arbitration is that it's more streamlined and less expensive. And so that's really good. Unfortunately, in practice, a lot of times that doesn't happen. Arbitration is always good, also good because it's a final decision. I mean, it's very difficult to overcome an arbitrator's decision. And so there's less incentive to appeal the decision. Whereas if, you get a decision by a trial court, there's, usually a couple of levels of appeals that people can make. So that's the good side. The bad side is that a lot of times it doesn't work the way it's supposed to. And so, and it's also expensive because you're paying the judge as well as attorneys. It depends. If it's short, it can be. And you can, arbitrations are contract agreements. And so you can construct a process that is short and sweet and could be less expensive for sure. So did you have a?
Is that something?
I do to a limited extent. If you're talking about dispute resolution, I'm more of a front end type person, not back end. I do help current clients to a limited extent, but I send people pretty early on to specialists who handle disputes. Yes, sir.
Yeah, Brian, on that interest provision and 1.5% interest provision, does the fact that you didn't use it during the course of the engagement, didn't employ it until you got correct, does that have any impact on it?
Yeah, that's a good question. It's a question of waiver. I mean, basically, the question is, did you waive your right to enforce the interest provision by not enforcing it along the way? And that is a little bit of a risk. In fact, if you look at the miscellaneous section of both the form contracts, there's a provision that expressly deals with that basically says that, a waiver or failure to enforce the agreement doesn't act as a waiver of the, your ability to do it later. So I wouldn't be overly concerned about it. But waiver is always is a possibility. If you have rights in a contract and you have a history, particularly over time, if you've got a client who pays late and you accept it, you never do anything about it, then you could be in a situation where even though the contract tries to overcome that, you could have a court that says you waive that right. So, all right, is that it? Oh.
Quick question. Looking over your agreements, they seem to be in very, what I'll call common language, right? And as you mentioned earlier, there's not a lot of whereases and lawyer speak in there. Is there a difference between enforceability of agreements that would use, simple language versus kind of lawyerly speak?
No, there's no, there's no benefit to legalese, except, I mean, in some cases there are magic words that you might want in there. For instance, in the attorney fee provision in Missouri, if you want your attorney fees to be paid by the other side, you have to say attorney fees. It's not that way in every state, but it is in Missouri. But as far as using kind of traditional language versus not, you could read 100 cases of contract cases, and the court in their opinions will say, what the rules are for interpreting the contract. And they always say that what they're trying to do is basically enforce what the party's agreement was. So that's what you're trying to do, is memorialize the party's agreement. I think using standard English Clear language is better than language that people may not understand, because it's important to actually capture, for both sides to understand what they're agreeing to, and so that you capture that. And sometimes legalese, I think, can obscure the real meaning of what you're agreeing to. So I prefer it. So, yes, sir.
Situation I've run into is that the parties will experience what's going to be a problem, what they anticipate is going to be a problem in the relationship.
Mhm.
And they don't say anything. And they sit on it and they wait until it gets really bad. And so what I've found is that that it's a better practice that if you see a problem in that relationship, or you see a problem in that, that they're chronically late on payment, or there's something like this, make an issue of it, get it out there, get communication out there, and establish a record that that there is this problem, so that if it finally comes to a lawsuit or finally comes to arbitration or whatever, you've got this clear record and you're in the position of saying, look, I told them all along, here was the problem.
Yeah,
There's no surprises here.
Yep.
That kind of.
that's great advice. And we'll end on that.